Thank you. Thank you for that introduction. I should say, actually, I'm very critical of wokery, but from a liberal perspective rather than a right-wing perspective, but I think that's also a growing tendency. So, despite being from the University of Bristol, I'm actually just going to play this with a pretty straight bat and just lay out what the law is, and then we can have the debate in the light of what the law actually is. It's quite narrow and specific. And my suspicion in relation to some of the information about this session is that the police have at times blamed contempt law for why they're unable to release details, information about a given suspect or defendant, when in fact contempt law has nothing to do with it at all. And it's never been the case, certainly, that contempt law prevents the police from releasing details of a charge or a suspect's ethnicity or his age or anything else, as I shall explain. As a preliminary point, I couldn't resist this one, we should note that we actually owe the more liberal regime that we have now under the Contempt of Court Act 1981 to a judgment of the much reviled European Court of Human Rights and a case called Sunday Times versus the UK in 1979. It's often said by those hostile to the ECHR that we don't need it because we have the glories of the common law. Well, the common law in this area, before it was reformed following the Sunday Times case, provided very little protection for press freedom and was also very far from clear. And some of you may remember the Sunday Times case itself came about because that newspaper was issued with an injunction to prevent it from publishing what was admitted to be serious and balanced articles about the thalidomide scandal because of the fear they might prejudice civil proceedings that were then underway, although they were often described as dormant. That injunction was upheld by the House of Lords, our then highest court, despite the huge public importance of that issue and the fact that the article in question that was injuncted was a solid piece of investigative journalism. So at that point, the law allowed injunctions to be granted where there was conduct, whether intentional or not, that was liable to interfere with the course of justice in a particular proceedings. There was no defined time limit, as there is now for the stage those proceedings had to be at. They merely had to be imminent, a term that lacked clarity. And not surprisingly, the European Court of Human Rights found that the injunctions breached the Article 10 right to freedom of expression. So the result was the Contempt of Court Act 1981, and that act made a number of key changes. So first, the contempt regime only applies when proceedings are active, and what that means is clearly set out in a schedule to the legislation. Essentially, the active period in criminal cases starts at the point of arrest or service of an indictment and concludes at the end of the trial. And during that period, the so-called strict liability rule applies. And under that rule, it's an offence to publish material which creates a substantial risk that the course of justice in the proceedings in question will be seriously impeded or prejudiced. So note that dual requirement. The risk has to be substantial and it has to be of serious prejudice. And applying that test, courts have tended to find the greatest risk comes from articles containing seriously prejudicial material that are published during or shortly before the trial. Where the trial is many months away, courts have tended to rule that even if potential jurors had encountered the article, they probably wouldn't recall it by the time of the trial. And I'd say there's been a pronounced trend in the case law since the 80s that's tended to raise the requirements for showing the risk of serious prejudice really is a substantial one. And then finally, even if an article does create a substantial risk of serious prejudice, there is a defence under Section 5 of the Act that applies to an article which is or contributes to a discussion in good faith of public affairs or other matters of general public interest, if the risk of impediment or prejudice to particular legal proceedings is merely incidental to that discussion. I don't actually think that wording is very helpful. The term incidental is a bit of an odd one. But the idea is not to criminalise articles that are seeking to highlight matters of serious public concern where the prejudicial material, where the focus on the upcoming trial is not the main one. The final point to note is there is a residual common law offence in this area and preserved by the Act. This only applies to intentional contempt. So those cases where courts have found that articles were intended to cause prejudice to legal proceedings, which means at least that the editor must have foreseen that the suspect would almost certainly not receive a fair trial as a result of the publication. Rather than, as under the statute, a substantial risk of serious prejudice, it only requires a real risk, and as before, it applies to proceedings that are imminent, as well as those that are active, and a term that the courts have still really failed to clarify. Because of the requirement of specific intent, it's very rarely prosecuted, in fact, but I'm afraid it is another area where the common law rather undermines the protection for press freedom provided by Parliament. So from what I've said, I hope it's clear that the simple release of factual details about a suspect, name, age, ethnicity, nationality, etc., could never amount to contempt, since in themselves they pose no risk at all of prejudice in proceedings. Also note, as the thing says, the Law Commission is currently investigating this area and may recommend reforms, perhaps shortening the active period and reforming the public interest defence. I'm sure we'll talk about that. Thank you.